Okay, we're good. Mhm. All right, the court is going to call 2025 CR 005408 State versus Carlos Perez. Could I have parties announced for the record for the state?
Lauren Espinoza and Megan Galloway for the state.
Roberto Rosino and Thomas Tyria for.
And are you Mr. Perez? All right, so what we'll do is I'll bring the jury in, swear them in. Both sides will be given an opportunity to have opening statements. If you choose to have opening statements, then both parties agreed that the state would call one witness. Then I will let the jurors recess until tomorrow, and we'll start tomorrow at 1:30. And then outside the presence of the jury, I'll hear whatever motions to suppress you have. All right.
Judge, can I approach?
Yes.
We have an answer on Mr. Cedillo. So the prosecutor doesn't want.
Another
Oh, we need an
prosecutor can do
interpreter.
it, and just the circumstances, the other cases.
And Jerry, just let them know that we'll do it during the break. The state has one witness, and then we'll take it up in the middle break. We're ready.
The jurors already said that they have to pick their child.
All right, everyone, please be seated. Ladies and gentlemen, I'm going to swear you in. And I know you took an oath downstairs, but this oath is for this specific trial. If you could raise your right hand for me, please. Do you and each of you solemnly swear that in the case of the state of Texas versus Mr. Perez, you will a true verdict render according to the law and the evidence, so help you God? All right, you can lower your hand. State.
Do you want the defendant to rise?
Thank you.
True bill of indictment. In the name and by the authority of the state of Texas, the grand jury of Bexar County, state of Texas, duly organized and paneled and sworn as such at the March-April term AD 2025 of the 227th Judicial District Court of said county in said court at said term do present in and to said court that in the county and state aforementioned and anterior to the presentment of this indictment on or about March 7th, 2025, Carlos Perez, hereinafter referred to as defendant, did with intent to harm or defraud another and without the effective consent of Clinton Butler, hereinafter styled as the complainant, possessed less than 5 items of identifying information of the complainant, namely unique electronic identification number, address, routing number, or financial institution account number, to wit, a check containing complainant's routing number and account number. This, the peace and dignity of the state, signed foreman of the grand jury.
Right, to that, how do you plead?
Not good.
Right, you may be seated. State, do you have any opening statements?
Briefly, Your Honor. Ladies and gentlemen, on March 7th, 2025, police were dispatched to the Wells Fargo Bank at 6919 South Zarzamora for a report of a male attempting to cash a check that did not belong to him. The evidence will show that police responded shortly thereafter and that they began investigating this scene. The evidence will show that the check attempted to be cashed by a man identified as Mr. Perez did not belong to him. It had identifying information of Mr. Clinton Butler, and the evidence will show that Mr. Clinton Butler did not provide consent to have that information. At the end of hearing all the evidence and seeing all the testimony of the witnesses we have before you, we'll stand up here and ask you to render a guilty verdict.
All right, defense, any opening statements?
Yes, Your Honor.
You may proceed.
Good afternoon.
Good afternoon.
As I said, my name is Roberto Ambrosino. I represent Carlos Perez. The evidence will show that Carlos is 53 years old, that he is from San Antonio, that he's lived here his whole life. The evidence will show that he worked at HEB for 29 years, and that he had retired a few years ago and started his own landscaping business. The evidence will show while doing that landscaping business, he started taking checks and accepting checks from people for work that he had done. As the judge had mentioned, Carlos is accused of having fraudulent identifying information with intent to harm another and without consent. That's the part that you're going to decide here today. The evidence will show that there is not evidence of that. The evidence will actually show that my client, Carlos Perez, is a victim in this situation as well. The evidence will show that he was given a check that was fraudulent, at which time he cashed and then was not aware that was not a good check. The evidence will show that the police did not do a good job in this case. The evidence will show that whenever the officers went to the initial bank at the Wells Fargo on March 7, 2025, they immediately put the wrong person into cuffs. That they were willing to rush to judgment. The evidence will show then they immediately put my client into cuffs as soon as they released the wrong person. The evidence will show that they didn't even ask him for his version of the events until he was already in cuffs. They never wanted to hear him out. The evidence will show that they did a very poor investigation. The evidence will show that they took fingerprints of the check. But the fingerprints don't prove anything because it's not even in dispute whether he actually had the check in his possession. The evidence will show that they did not do any other significant type of evidentiary analysis. Carlos didn't suspect any wrongdoing. The evidence will show that he was surprised as anybody when he went to cash the check and the bank wouldn't cash it. The evidence will show that the complaining witness in this case is named Clinton Butler. That he actually turned out to be a former DA that used to work for the Bexar County District Attorney's Office. The evidence will show that whenever the police department realized that he was a former DA, that the police wanted to really prosecute the case, and they wanted to be more aggressive about it. And Officer McFadden, the main arresting officer, kept telling other people that he was a
Judge, I
former
would
DA.
object as to hearsay and
Withdrawn. I'm confident after you hear the evidence that you will find my client guilty.
All right, state, call your first witness.
State calls Clinton Butler.
Good afternoon. And if you'll put the square microphone on it, it's gray. It's for the court reporter.
Right.
Yes, if you'll put it on your lapel or somewhere. Yes. All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Good afternoon. My name is Clinton Butler.
All right, state, you may proceed.
Thank you, Your Honor. Mr. Butler, do you currently live in Bexar County?
I do.
Are you a native San Antonian?
I was born in Cuero, Texas. I moved to San Antonio at the age of 9.
Are you married?
I am.
What is the name of your spouse?
Patricia Aguilar Butler. Martha Patricia Aguilar Butler. She doesn't like Martha.
Do you have any children with Patricia?
We do. We have a 14-year-old Isabella and a 12-year-old Valentina.
How are you presently employed?
I'm an attorney with the law firm of Jackson Walker.
Mr. Butler, do you have a bank account?
I do.
Where do you do your banking?
We currently
Do you recall when you opened an account at Wells Fargo?
2014, 2015, something like that. I can't give you an exact date, but mid-teens.
And is that account still active?
No, we closed that account, I believe, in July, and we opened up a new account at Wells Fargo.
So you stated you opened a second account at Wells Fargo, correct?
After we closed the one that is at issue here today.
Okay. So when you switched accounts, did the account number change?
It did.
What account were you using on March 7th, 2025?
As far as the account number,
Yes.
be helpful. I don't have the account number memorized.
Your Honor, may I coach?
Yes.
Mr. Butler, I'm gonna hand you what's been marked at State's Exhibit 1. Would you please take a look at it and tell me if you recognize it?
This appears to be a check.
Yes, or no?
Oh, yes, I do recognize
Yes, you
it.
have
I'm
to
sorry.
recognize it.
As far as what is on the picture, I recognize it because
What is it?
this is a check that
Okay,
came.
perfect.
Yeah.
We're gonna break it down, don't worry.
Okay.
Okay.
I'll
so
follow
on
you.
the check is your name.
Is my signature or is my
Is
name?
your printed on?
My name is printed on it. Yes, ma'am.
Okay, is this a check that you had received from Wells Fargo?
This was a check that was,
Objection leading. Objection non-responsive, objection to sidebar.
All right, with regards to your objection to leading, that objection will be sustained as to leading.
Looking at the check without getting into specifics
Mhm.
on it.
Okay,
Okay, actually, let me withdraw. Did you ever receive checks from Wells Fargo?
I did.
And how did you receive those?
We got a like a book of checks where, you know, you would open up the booklet and there would be like three checkbooks on one side, three checkbooks on another.
Okay, and with those checkbooks, you ordered them from Wells Fargo, is that correct?
Yes, we asked Wells Fargo to send us checks as part of our checking account.
And the checks that you received from Wells Fargo, did those contain identifying information?
As far as my wife's name, my name, and our address, they did.
Okay, so on the checks that you received in March 7th, 2025, what address were you living at? Okay. When did you move to with the photo? It is a photo of a check you testified to, that correct?
It is a photo of,
Is your name, sorry, and is your name on that check?
it is printed on this check. Yes, ma'am.
And the address you just relayed at L Manor, is that,
On this check. Yes, ma'am.
and that check, is it a fair and accurate depiction of the checks you had at the time you resided at the L Manor address?
It is.
To your knowledge, has it been the check itself, has it been altered and amended anyway from the state at which you received it from Wells Fargo?
As far as just in its original form, no, it appears to be a true and correct copy of the check as we received it from Wells Fargo.
At this time, your Honor, state offers what has been marked as State's Exhibit 1.
Judge, I would object to this witness authenticating this particular check. Literally, their case is that this
I'm
check
gonna
was
object to
doctored.
the sidebar. We can approach, but as far as getting into facts or what he believes the witness.
I can say whatever I
All
want.
right, yeah,
Actually.
all right, so here's the
Well,
thing.
you can't.
The
There's a
court-
rule against sidebar.
The
so-
court-
I'm making an objection.
Time out, time out. The court will hear any legal objections. So what's the legal objection?
The legal objection is that they have not laid the proper foundation to authenticate this check. Their case is that. the
No,
check
no,
was
no,
doctored.
your objection is authentication improper? Is that,
Yes, Your Honor, with this witness.
all right, could I see State's Exhibit number 1, please?
No.
All right, could I have parties approach?
You have such fancier toys than when I was the DA's office.
So looking at State's Exhibit 1, can you please direct us at where your name is on this check, like description?
My name is in the top left corner below my wife's name.
Okay, perfect. And in the top right corner, can you please read me the number? Okay, so because we have a check here, were you able to draw checks on this account, Mr. Butler?
Was I able to write checks on my account? Yes.
Okay, perfect. And who had permission to draw checks from this account?
The only two people that were permitted to sign checks on this account were myself and my wife, Patricia Butler.
Mr. Butler, why are you here today?
I'm here to testify regarding a alleged stolen and stolen check that somebody, that's not my signature, so somebody forged my signature.
I would object. He is not competent to testify about handwriting sample.
I can identify my signature, sir.
And I'll object to the
So-
witness responding to me. That would be a sidebar comment. He's answering, he's being non-responsive. not
All right,
sidebar.
so everyone make the objections and I will respond to the objections. With regards to your objection to handwriting and whether or not that's the state's signature, that will be sustained in state. You'll have to lay the foundation.
Yes, Your Honor. When did you learn that a check was attempted to be cashed? That
I don't know the specific date. I believe it was sometime in the spring, maybe in the summer of 2025. I received, oh, that's the answer to the question.
and then how did you learn of these checks being?
My wife checks our bank account and the check number six.
Objection hearsay.
That'll be overruled. You may continue to answer the question.
Could you re-ask the question?
Yes, I said, how did you learn somebody was attempting to cash a check from your?
Sure. My wife checks our bank account statements regularly, and this check number was not in the sequence of checks that we had.
Objection hearsay. His testimony is that the wife checked the bank account. She's the one that did it, not him. She would have told.
All right, with regards to hearsay objection. Response.
And also objection to Crawford. She not heard this.
Your Honor, he has personal knowledge of the event, and he was the one that was contacted by the bank regarding, and he was an authorized user on, it was his account, and so I believe that.
All right, so the objection will be sustained. You'll need to lay the foundation for his testimony.
I can rephrase the answer so it won't have
I
a.
will object to him talking when he's not.
All right, so ladies and gentlemen, time out. So ladies and gentlemen, I'm gonna have you step outside in the hallway. Just give me a moment, all right?
All right, the jury.
All right, everyone, please be seated. So everyone, this is how it's going to go because everybody here is an attorney. And everyone should know the rules. These are the rules. Number one, if there's an objection to be made, The person can make the objection. It must be a legal objection. Let everybody make their objection. Then I will ask for a response to the legal objection, and then I will make my ruling. Does everyone understand?
Yes, Your Honor.
To the witness, just answer the questions. I know that everybody here is an attorney, but you just have to listen to the question that's being asked and answer only the question that's being asked of you.
I apologize. Your
All right. So, and the other thing, it seems that it will help with everyone if, when you make your objections, just remain seated. All right.
Yes, Judge.
All right, let's bring the jurors in.
All right.
All right, everyone, please be seated. All right, State, you may ask your question.
Okay, so Mr. Butler, after you noticed activity on your account what did you do next?
After I reviewed the bank statements for myself and saw the checks were out of sequence, and then looked at the checks to see that I was not familiar with that handwriting or that signature, I contacted Wells Fargo myself. I told Wells Fargo,
I'm gonna object again. It was stated on the handwriting. I objected. He's not competent to testify on handwriting. We sustained my objection.
All right, so the parties approach. All right, you may continue.
Mr. Butler, do you know how to read and write?
I do.
How long have you been reading and writing?
I think I learned to read and write when I was in kindergarten, maybe first grade.
Do you have a signature that you use?
I do.
How long have you been using that signature?
I started using that signature when I worked at the San Antonio or Bexar County District Attorney's Office in 2005.
Are you able to identify that signature?
I am able to identify my signature.
Do you see that signature on check number 674?
I do not.
So what did you do when you noticed an attempted transaction on your account?
I contacted Wells Fargo, told them that that was not my signature. I did not authorize that check, and requested a reimbursement from Wells Fargo for the amount that was drawn on my account.
And when did you notify Wells Fargo?
As far as the date,
Yes.
like I said, sometime in the spring or summer of 2025.
To your knowledge, was a hold placed on your account?
As in, like, my account was frozen?
Yeah, or just any kind of hold?
No, the check amount was refunded.
Okay. To your knowledge, do you ever recall losing a checkbook that belonged to the account ending in 7945?
Did not keep the checkbook.
To your knowledge, was a checkbook to that same account ever stolen?
I am not aware.
Do you know an individual by the name of Carlos Perez?
I do not.
Have you ever written a check to an individual named Carlos Perez?
I'm not aware of doing so.
To your knowledge, has your wife ever written a check to a man named Carlos Perez?
Not to my knowledge.
Objection.
Untimely, and it will be overruled.
Did you give consent to anyone to write a check on your behalf for the account ending in 7945?
No,
In March of 2025, did you hire Mr. Perez to perform any work in exchange for payment?
I did not.
Did you hire anybody in 2025, March of 2025 to perform labor for you?
I'm sure we did. We had a handy guy that would do work around the house, Angel Vasquez. But Angel was the only person that we used, and any payments to Angel or anybody that he worked for Angel, we made the checks directly to Angel.
So you said you may have made checks in 2025 to Mr. Vasquez, is that correct?
Angel Vasquez, yes, or his brother Luis.
Do you recall the series number of checks that you were in approximately of March 2025?
I don't, but it was much higher than this. I wanted to say it's like in the 11 or 1200s.
So this check that was presented on or about March 7th, 2025 would have been out of series for the checks you were using at the time.
That's what initially drew our attention to it.
Okay. Have you moved from the address at 125? To your knowledge, does this States Exhibit 1 contain the routing number to your bank?
It does.
And what is the routing?
I do not.
Did Mr. Perez have consent to possess a check issued by you?
He did not.
And then, did Mr. Perez have consent to attempt to cash a check?
He did not.
Okay. I pass the witness, Your Honor.
All right, defense, you may proceed.
Yes, definitely.
Good afternoon.
You used to work for the Bexar County District Attorney's Office, yes or no?
Yes.
What months and years?
Started in November of 2004 and left in December of 2005 to go to the Travis County DA's office,
For the Travis County what?
District Attorney's office.
And how long did you work for them?
From
Check
O-
as to relevance.
All right, what is the relevancy?
I'll withdraw.
All right.
So on March 7th of 2025, whenever officer, let me back up. On March 7th, 2025, when this check 674 was presented to Wells Fargo, Officer McFadden, the arresting officer in the case, called you, right?
I believe that's correct. I don't remember the officer's name, but I know I was contacted by an officer, I believe SAPD.
And over the course of that conversation, you told him that you were a former assistant district attorney, right?
I did.
You told him that because you wanted him to take the case extra serious. Right?
No, he was asking me some formality questions. I told him we can skip this part. I know where you're going with all this. I'm a former district attorney, so we can move along.
When you had that conversation with Officer McFadden, March 7th, 2025. You didn't tell him about any of the work that you had hired Angel or Luis Vasquez to do at your house, right?
I don't know if that came up or not.
So the answer is no.
The answer is I don't recall.
You had been contacted by a detective on this case at some point, also, correct?
I believe so.
You didn't tell any of the police officers that you spoke with that you had possibly hired a Luis or Angel Vasquez to do work at your house.
I don't know if the question was asked. I don't know if I volunteered it. I don't know if I did talk about it and it just wasn't written down.
In a case like this, don't you think that would have been useful for their investigations?
I would hate to speculate on something like that.
On what dates did Angel Vasquez and or Luis Vasquez do work at your house?
Luis was our lawn guy, so every other week he was out there doing lawn stuff. My wife is she always had some little projects going on at the house, be it fixing up a bathroom or doing some little thing. So Angel was over there quite a bit, and we were preparing to sell the house as well. So um, I wouldn't be able to tell you how many checks we wrote to Angel, but I would say that each time Angel worked for us, the only person we wrote a check to was Angel.
How many checks would you say you wrote?
Oh, over 50.
Over what period of time?
Probably about a 3 or 4 year period.
So did either one of those individuals ever have access to the inside of your house?
Yes.
Uh, you never suspected that that's how your checks went missing?
Absolutely not. I know both those gentlemen very well. Angel's wife, Janet, is the nanny to our children. I trust both those gentlemen implicitly, and neither one has done anything other than be an extremely professional and upstanding person with me. So I have zero thought of either one of them being involved with this.
Right, but I'm sure you didn't do a criminal background check on either one of them, did you?
I did not.
Yeah, so you don't really know what their background is.
I just know them as human beings.
Fair enough. It's like Carlos Perez, human being, right?
Certainly, he's a human being, but I don't know him.
So for all you know, Angel Vasquez and Luis Vasquez could have all sorts of theft charges. You just don't even know.
Objection, speculation.
Sustained.
Good job. I think you misspoke. You said you requested a reimbursement from Wells Fargo, but they never paid this check out. Correct.
I know they paid 1 or 2 checks out. I know he tried to cash 3 or 4.
Objection, Judge, can we approach?
Yes. All right, ladies and gentlemen of the jury, you're to disregard the last question and the last answer. Does everyone understand? Is there anyone who cannot do that? All right, and I'll take that as everyone can follow the court's instruction. Is that correct? All right, defense, you may continue.
Yes. With respect to this particular check, check number 674. That check was not cashed, correct? Yes or no?
The answer is it's complicated for me to try to answer this check. The answer, I don't know due to other circumstances. Fair enough?
How often did you or your wife write checks?
I rarely write checks. Patricia would write checks for mostly for work that Angel or Luis did, but she wrote checks more often than I did. I'm not a check guy.
Did you ever speak to Angel or Luis about these checks?
Yes.
You didn't have any other type of home invasion or break-in around this time?
No.
Haslitz?
Thank you, sir.
All right.
Judge, can we approach?
Yes. Oh, come forward. Sure.
Sorry.
No problem. All right, we are going to go back on the record in 2025 CR 007-803, State versus Oscar Correa Hernandez. Can I have parties re-announced for the record, please?
Melissa Alvin from State.
Jerry Kagan on behalf of Oscar Seville.
And are you Mr. Hernandez?
Oh, yeah. Now here's
All right, do y'all close the door, please? All right. And for the interpreter, if you could raise your right hand. Do you solemnly swear or affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand, state your name for the record.
Carmen Tarragona Sáenz.
All right. So, Mr. Hernandez, where we left off, I accepted your plea. I found there was sufficient evidence to find you guilty. I had deferred finding of guilt as you had applied for deferred adjudication. And then I gave the defense and the state an opportunity to discuss things off the record. And so we are back here for sentencing. Do you wish to continue with this plea?
Yes,
And defense, have you had sufficient time to speak to the state about other options?
I have, Judge.
And do you believe your client wishes to continue with the plea? All right. Are you waiving the right to PSI and asking that the court
Yes.
sentence?
He's already been accepted, just here for sense.
All right, Mr. Hernandez, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes.
You can lower your hand, state your name for the record.
Oscar Carrillo Hernandez.
And I know you were previously sworn in by one of the clerks, but because there's been a lapse in time, just out of the abundance of caution, that is why I'm swearing you in again. So are you currently employed?
Yes,
And what do you do?
Home Foundation.
All right. Do you have any children?
No.
No,
And do you live by yourself or with someone?
with my brother.
All right. And are there any children in the household? And are they minors under the age of 17?
Yeah,
All right, this is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs or the patch. The patch costs more, but it helps if you are having to go back and forth to work. With the patch, they will place the patch on your arm and then they will remove it when it's time for it to be tested. There's going to be field visits 1 time per month for 3 months. Proof of employment within 30 days. No employment as a home health care provider or with minors. There's a $1,000 fine that will be probated. There's to be 120 hours of community service restitution. I'm going to order 60 sober support meetings in 60 days. Once those are completed, the community service hours will be deemed satisfied. Probation, is there anything else? All right, and I'm so sorry, there's to be restitution for laboratory testing. And if an amount is not provided to probation within 30 days, then it will be deemed waived. Yes. Just one moment.
I believe it's the Bear County Crime Lab, Your Honor.
All right. It is the Bear County Crime Lab. Is there anything else that you need from the court in order to be successful on this deferred adjudication?
No.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
To be successful on probation in this court, communication is key. If you have an issue, let the probation officer know. If you feel they're not addressing it, you can come to the court and address it with me. And if you complete everything successfully early, the court will consider early termination.
Thank you, Judge.
Thank you. All right, you're welcome. Probation will go over conditions with you.
Your Honor, may I have you?
Yes, thank you so much. It's always good seeing you.
My pleasure.
All right.
Can I make a plug, Your Honor?
Oh,
My wife is also a court interpreter, and she's getting back into.
oh, wow.
And so if y'all ever need one, I'd be happy to introduce.
Oh, sure. The person you would speak to would be Anna Amici.
Okay.
Yes, and she is in the court admin.
Okay.
All right, thank you.
Thank you.
All right, we're back on the record and 2025 CR 0054008 State versus Carlos Perez. Can I have parties announced, please?
Lauren Espinoza and Megan Galloway for the state.
Roberto Ambrosino and Thomas Tiarina for the defense.
And you're Mr. Perez?
Yes, sir.
All right, everyone, please have a seat. We're having a hearing outside the presence of the jury. It's in relationship to extraneous offenses. Is that correct?
Yes, sir.
All right, you may question the witness.
Mr. Butler, did you go through your bank statements on or about March 7th, 2025?
Yes,
What did you notice when you went through these statements?
that there were numerous checks that were in and around this sequence of 674 that were for amounts similar to the 1100. They were like for 900, 800, something like that, that had been cashed by Wells Fargo. And that's what I noticed.
Okay, and you mentioned the check number 674. Do you recall whether that was around the number of check you were writing on at that time?
No, it wasn't.
So it was out of order?
Very much so.
Okay. What did you do when you noticed these checks that were out of order?
Once I noticed the checks that were out of order that had already been cashed by Wells Fargo, I contacted Wells Fargo, told them that, well, I looked at the checks online. I pulled up pictures of the checks online, looked at the check, noticed I don't know who Mr. Perez is, noticed that wasn't my signature.
Judge, I didn't object to him testifying about checks that he saw online.
All right.
That's evidence.
All right, that'll be overruled. You may continue.
Thank you, Your Honor. And at that time, I contacted Wells Fargo, told them that I don't know what these checks are. I didn't write them, that somebody else enforced my signature, and that I wanted the money refunded. At which time Wells Fargo began a fraud investigation.
Objection.
Okay, well,
All right, that'll be overruled. This is a hearing outside the presence of the jury. It's for the court to make a determination on whether or not any extraneous offenses, any alleged extraneous offenses are to be admitted before the jury.
Wells Fargo told me they were going to conduct a fraud investigation. They then contacted me a couple of days later, told me the fraud investigation was complete and that the amounts would be refunded. At which time they were.
At the check that you observed online, did you write those checks?
I did not.
Did you authorize anybody to write those checks on your behalf?
I did not.
I pass the witness, Your Honor.
All right, defense, any questions?
Yes, specifically these checks that would have been in this batch, this 600 batch you're referring to.
Yes,
When would you have ordered those checks?
I don't know.
Around that,
I don't.
like 5 years ago,
The answer is I don't know.
10 years ago?
It wouldn't have been 10 years ago because we would have been living at the Elm Manor Street address. And so it would have been after 2009. So it would have been in 2024.
So you told the officer that you were currently on in the 1,200 checks.
If that's what I told the officer at the time, then that's correct because I would have looked at what our checks were.
So is your testimony that you have written like 500 checks since then?
Is it possible my wife did so? Yes, but also, like I said, we got checks in a booklet. So like there may have been like a booklet and the booklet had 6, check books in them. So, it's possible that we had like a 600, a 700, an 800, a 900, a 1100. We could have had, I don't know how many checks at one time. So do I think we wrote 500 checks? Probably not. Do I think my wife was writing a bunch of checks? Yes.
Okay, so your wife is the one that writes all the checks.
She writes the majority of them.
So wouldn't she have been the person who had care and custody control checkbook?
I mean, it was in our house.
Okay, but you don't write any checks. She does.
Correct. She would go to a drawer, pull out the checkbook, write a check, and then put the checkbook back in the.
She writes so many checks, she could have, you said that she could have written almost 500 checks in 2 years.
Judge, I'm gonna object as to outside of the scope, like what is this line of questioning? have to do
Sustained.
With
I
what
think it
we're-
establishes that he really didn't know what was going on with his check. He doesn't
No,
have-
but that's
Good.
how, but, all right, so everyone, I'm gonna listen to objections. I'm gonna make rulings on the objections. With regards to the purpose of this hearing outside the jury's presence, it is for whether or not any extraneous, alleged extraneous offenses are to be introduced before the jury. Everybody who wants to cross or direct this witness on something else, you can do that in the presence of the jury. So you may ask your next question.
Yes, so you told Officer McFadden there was a check 669 that was for $890, right?
I don't have that report in front of me. It sounds familiar.
Did you turn in a copy of that check to the state?
I don't have a copy. I didn't have that check.
Okay, but you just testified that.
Oh,
online,
did I-
You
did
saw
I-
that there was a check that was written to Carlos Perez, you didn't write.
I understand what you said now. I understand the question. I'm sorry. No, I did not print off a copy of that from my account and tender it to the state. I don't believe I was ever asked.
We don't have that here to see, you did.
I was never asked to deliver it.
And there was also a check 672 for $930. Basically same thing, right?
Yes,
Were there any other checks in between these other checks?
I do not recall. I think it was just 2 that he cashed. It may have been 3, but it was 2 or 3.
When was check 672 written?
It was cashed. I don't know when it was written. It was cashed in and around the same time that 674 was attempted to be cashed. As far as when Mr. Perez or somebody else wrote it, I don't know.
When was the last check used from this batch that wasn't allegedly?
The 600 batch?
Right.
I don't know. We didn't investigate that.
Thank you.
Any other questions?
Mr. Butler, you stated that there were 3 checks, correct, that you noticed that were out of series,
2 or 3?
2 or 3, okay. For check number 669,
Mhm.
do you recall the value that was for that check?
It was around $1,000.
Okay. For check number 670, do you recall the amount?
It was around, they were all between $800 to $1,100.
Okay.
The exact amounts I don't recall at this moment without seeing the checks in front of
And
me.
these checks, they were observed by you on your online account?
Yes.
And is that through like a portal? Do you?
I go online, you pull up your statement, you can look at the withdrawals, and there's a little button that you press, and when you press that button, the image of the check comes up, the front and the back.
And who were these checks written out to?
Carlos Perez.
And did you write these checks out to Mr. Perez?
I did not.
What did you do after that?
What did I do after I noticed them online?
Correct.
I contacted Wells Fargo.
And all these checks, were they all written out on or around the same day?
I don't know.
Of the March 7th.
I don't know the date of the check. They were all, I believe, in March, because they were all attempted to be negotiated within a 4 to 5 day period.
Okay. No further questions, Your Honor.
Yes.
So you agree that there's gaps in the checks that you're saying that are stolen?
As far as like the number sequence,
Yes.
I believe that's correct.
So you said there was 669, 670, and 672. What about 671? You know what happened to that check?
Again, I don't know the numbers offhand. So if you're telling me that's what I had told the detective, you know, I'll certainly go with that. But as far as, do I know what happened to those checks now?
Were there other checks that were stolen or forged around this time? Other
No,
checks?
these are the only ones we had that we noticed.
After all this, did you cancel that checkbook? Whenever it was left?
We changed accounts. So all the checks that, you know, pertain to that account were null and void.
You said, going back, you said that signature wasn't your signature, but was it close to it?
The C is somewhat close, but the two L's, nothing like what I did.
Thank you.
All right. Any other questions?
None from the state, Your Honors.
All right. The court will hear argument. Now's the time for argument.
Who do you want to go?
Well, you had an objection saying that it is extraneous. The court is finding that it is extraneous because it is outside of what's in the indictment. So the next question becomes whether or not it is relevant. And then the next question at that, if it is relevant, then the question becomes whether it's more probative than prejudicial. So,
Judge, I would argue that if anything, that the state should have provided these other checks in discovery. They would have provided them in discovery and we had them and we could scrutinize them, but I think they would have a better argument. But they don't have the checks. They haven't tendered them in discovery, so I don't assume that they intend to use them in evidence. So for that reason, I don't think it's appropriate to consider that. Because I don't have them. We don't have them. We can't see them. We have no. So for that reason, they're purely prejudicial and they have no probative value and the jury could never scrutinize them, never look them or see anything else about them.
all right, state.
Judge, so while he argues that we didn't provide him the check, it's clearly stated in the prosecution guide, the check numbers, the amount that they were made out for, and who cashed them. So he's had notice of this, even though he's arguing that it wasn't in the indictment. It's the same criminal transaction contextual evidence that gives the finder of fact, it aids them in making a decision by showing the defendant's state of mind at the time that he was engaging in this conduct, and it's more probative than prejudicial. So we would ask that you allow it in so that the jury is able. Also, I mean, by defense asking the question, well, Wells Fargo did not really reimburse the check, that opened the door as to what the complainant was testifying to about receiving reimbursement for those other 3 checks. And so we would ask that you let it in as same contextual criminal transaction evidence, Your Honor.
All right, this is what the court is going to find. The court is going to find that the defense did open the door by asking the question with regards to reimbursement from the witness. The court is going to find that the mentioning of the other checks, the alleged checks, is relevant. However, at this point in time, the court is going to find that it's more prejudicial than probative. It may change depending on the evidence that is presented. The court will allow the witness to testify because I think it leaves a false impression with the jurors that somehow this witness received reimbursement when he should not have received reimbursement. So is there any objection to the witness answering this,
Yes, Judge.
stating that Wells Fargo did a review of his account and Wells Fargo made a reimbursement to him? If they made a reimbursement to him, based upon, if it's for a check that was endorsed to the person named on a check, Carlos Perez, then he can say that they made a reimbursement of him of a check that was endorsed to Carlos Perez. But we're not going to get into other checks.
Judge, I think I'd like to ask that the board reporter read back the sequence about that question, because I really don't think that
Well,
I was
what-
responding to her question where they asked, like, I had to clean it up based on the question that they asked. I said, were you paid on a specific event? That's all I asked. I asked a very precise question.
No, the court has made its ruling. And so the court is not going to allow the presentation of any physical checks. What the court is going to allow, and I'm sorry, I misstated. The court is finding that it's more probative than prejudicial, but this is how the witness will be allowed, or the question will be allowed to be answered, because you're stating you have not seen the checks. Is that correct?
Yes.
So based upon the defense's question, asking this witness about the reimbursement, the court, unless there's an objection, the court will allow this witness to answer that Wells Fargo did a review and Wells Fargo made a reimbursement to him. Because the court believes that it leaves a false impression with this jury that the witness received a reimbursement that the witness should not have received. Any response?
Yes, Judge. The issue is he didn't get any money back from his check. That was the point. And they were trying to make it seem like he did and that he was out money. They never cashed this check, so he never got any money back out of it. So that was the point I was trying to make. It doesn't make sense for him to say, well, yeah, I got some money back here. And I'm like, well, no, you didn't get any money back for this particular check, because he didn't. He got money back, I think, for the first check. Like, that's not a dispute. But that's not the check they indicted him on. They indicted him on this check. They could have indicted him on the other checks, but they didn't.
All right, is there anything else?
No, Judge.
All right, if you could bring the jurors in.
Judge, at this time, I'd also like to invoke the rule.
All right, the rule will be invoked. Are there any witnesses here?
Not
For
from
this
the
case?
state side.
All right. Thank you. Thank you.
I meant to do it.
Judge, just so we're clear, you said that the check numbers and amounts cannot be mentioned, but regarding the reimbursement, questions can be asked just regarding if they reviewed the account and issued the reimbursement.
Yes.
I'm trying to be clear on what I'm allowed to say that I was reimbursed. That's
Well,
it.
here's the thing. You're not allowed to mention the fact that there were other checks that had that were endorsed by someone to Mr. Perez.
Okay,
You are allowed to say, because the door is open, you're allowed to say that Wells Fargo's did a review of your account and Wells Fargo made a reimbursement to you.
very good. Thank you.
Yes,
Make sure I'm clear.
sure. Yes, we're ready.
All right.
All right, please be seated. All right, you all may proceed with your question of the witness.
Mr. Butler, did Wells Fargo do a review of your bank account with them?
That's my understanding.
Did Wells Fargo determine you were entitled to a reimbursement on this account?
I was.
Did you receive a reimbursement on this account for any check endorsed to Carlos Perez?
Yes.
And then regarding State's Exhibit 1, that is being published, did you author any portion of this check at all?
Did I author any portion of that? No.
I passed the witness.
All right, defense.
Yes. You don't know that Carlos Perez actually signed the check.
I have no knowledge about any of that.
The checks that are in this batch, the 674, when did you order these checks?
I don't know.
Is it more than 5 years ago?
It would have been after January 1st, 2020, because we moved into the Elm Manor Street address in late December of 2019.
You stated that you're currently on check. Like, you told the officer at the time in March of 2025 that you were in the 1200s check.
If that's what the report says, yes, sir.
So you had written maybe 500 checks in it?
No, as I stated earlier, we had a booklet of checks. So you'd have like 6 checkbooks in this booklet. One would be like the 600s, one would be the 700s, one would be the 800s, one would be 900s, one would be whatever. So is it possible that my wife or me wrote checks out of sequence? Maybe, but is it also possible that she wrote 500 checks? Yes, that too. So
Yeah.
I don't
it's
know.
safe to say that she's the one that wrote most of the checks.
I think that's a very safe thing to say.
So the care, custody, control of the checkbook is really your wife.
No, because it was in our house and we had shared obviously custody of our house. And so, it was in a drawer in the kitchen that both her and I had equal access to. She just, like our credit card, used it more.
So anything in your house that you have equal access to is under your care, custody, control too?
I would believe so.
And with like feminine products, it's under your care, custody, control too?
All right, what's the relevance?
Well, he's saying that anything in his house.
All
is
right,
under
you can
his
answer
care,
the.
custody.
you can
Sure,
answer
I'll be
question.
happy to answer. Yeah, I have possession of them. I don't use them very often.
Sure. Well, that's-
No further questions for this witness, Your Honor.
All right, is the witness excused?
Yes, from the state.
I'm sorry.
Is the witness excused?
Yes, sure.
All right, the rule has been invoked. You're not allowed to share your testimony with anyone until this case has concluded.
No, the excuse, Your Honor.
Yes,
Thank you.
thank you. You're welcome. All right, ladies and gentlemen, I'm going to excuse you for the remainder of the day. You've heard some evidence in this case. You're not allowed, thank you. You're not allowed to discuss what you've heard with anyone. You're not allowed to start deliberating. You're not allowed to do any investigation. Don't go Googling anybody's names or view anything. You are allowed to let people know if they ask you whether or not you're on a jury, you can tell them you're on the jury, but you just cannot discuss anything that you've heard. Does everyone understand?
Yes.
All right, so we're going to be back tomorrow at 1:30 and we can go off the record. I'm bringing you all back at 1:30 tomorrow because I have a docket in the morning. So we cannot start unless everyone is here. So the same number of jurors that were here this morning when you were brought down for jury selection are going to be the same number of jurors tomorrow. So to make sure that you have parking space, it would be best if you appear here no later than 12:30. Does everyone understand? I have no control over the temperature in this courtroom. Some people say it's too cold. Some people say it's too hot. We don't complain about the cold because it used to be probably about 89 to 90 degrees in here. There's a thermostat behind me. It does not work. If it will help anybody, I will get up and touch it so that people can say, oh, she's trying to change the thermostat, but it doesn't work. I know the chairs are hard. If you have pillows from home that you want to bring, you're more than welcome to bring that. We do have some pillows in the back that you're more than welcome to use. There's a refrigerator, toaster oven, and microwave in the back. If you want to bring your lunch, you're more than welcome to do so. No one will touch it. All right, everyone, please rise for the jurors. Are your witnesses present?
They are, Your Honor.
All right, so we'll have this hearing outside the presence of the jury. All right. And do you have the defense's motion to suppress? He put it under the motion in limine. Yes, that's fine. Thank you.
You're very
Yes.
Have that juror.
All right, this is a hearing outside the presence of the jury. It's a motion to suppress, and the motion to suppress is related to body cameras and to a statement that's alleged to have been made by your client.
Yes, sure. The body cam. Space, yes.
All right. State, call the witness, please.
State calls Alex Shawe.
Right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am, I do.
All right, you can lower your hand. And did you put the little gray microphone on?
I did not.
It's for the court reporter to hear.
Yes,
All right, could you state and spell your name for the record?
first name is Alex, Alex. Last name is Shawi, Shawe.
All right, state, you may proceed.
Officer Shawe, were you on duty on March 7th, 2025?
Yes, ma'am.
Were you dispatched to any calls that day?
Yes, ma'am.
Were you dispatched to a call at 6919 South Zarzamora?
Yes, ma'am.
What location was that?
It is the bank.
What bank?
I can't recall off the top of my head.
Is that in Bear County?
Yes, ma'am.
Okay. So were you the only officer assigned to that call?
The negative.
Do you recall who was also assigned?
Officer McFadden.
Okay, when you get dispatched to a call, do you learn information regarding the call prior to your arrival?
Yes, ma'am. It's limited, but we get descriptions and the basic knowledge of what's going on.
So you arrived to the scene with basic information. Is that a fair statement?
Yes, ma'am.
On March 7th, 2025, were you equipped with body worn camera?
Yes, ma'am.
To your knowledge, was it operating properly?
Yes, ma'am.
Okay, Your Honor, may I put?
Yes.
Officer Shawe, I am handing you a disc. What is this?
This is the body cam footage.
How do you recognize it?
We watched it earlier.
Is it a fair and accurate depiction of your body worn camera on March 7th, 2025?
Yes, ma'am.
At this time, Your Honor, state would move to admit Officer Shawe's body worn camera. That's going to be marked as State's Exhibit 1. I'm sorry.
It's gonna be M1.
M1. So sorry.
No problem.
This is the redacted one.
This is not.
Objection.
All right, so M1 is admitted for purposes of this hearing.
Permission to publish, Your Honor?
Granted.
Thank you. When you arrived to the bank, did you detain anybody?
Not originally on scene.
Not originally on scene? What does that mean?
Not at first. I made contact with the complainant first.
Okay, and then what did you do?
Spoke with the complainant who gave the better description and pointed out the defendant.
Okay, and based on that description, did you observe somebody matching that description?
Yes.
Okay, and then at any point did you detain a suspect?
Yes.
Okay. What did you do next?
Walked him out of the building, placed him in the cuffs, into the back seat of the vehicle, and turn on the rear camera and the AC, and then Mirandized the suspect.
Okay, did you pat down the suspect?
Yes.
Why?
Just officer safety, make sure there's no weapons because he was going back into the vehicle.
Okay, and you stated you Mirandized the suspect, is that correct?
Yes.
Why did you Mirandize him?
At the time, we had reasonable suspicion that a crime was committed.
At that time, was the suspect placed under arrest?
Negative. He was just detained.
Did the suspect ever ask if he was under arrest?
Yes.
What did you tell him?
I advised him that he was not under arrest and he was just detained.
What did you do next?
I just asked a basic question from the suspect's point of view on what was happening.
I'm Playing state's exhibit at 1 minute and 37 seconds.
So what's going on?
So Officer Shaway, this is the bank you responded to, correct?
Yes, ma'am.
Okay, and this is when you stated you went inside and you talked to the Wells Fargo employees, correct?
Yes, ma'am.
Okay. Resuming state's exhibit at 2 minutes and 20 seconds.
That's fine. Okay, that's fine.
Playing state's exhibit at 3 minutes and 8 seconds. Oh.
Yeah, ready? There was a check. We did everything on clock set.
The officer, you stated you patted him down. Is that what's being depicted here?
Yes, the officer gave consent to get everything out of his pockets.
Okay. Playing state's exhibit at 5 minutes and 20 seconds.
Sit up. Turn the AC on and I'll be right back. I'm gonna blow your property and stuff. Okay, well, we're not worried about that right at the moment.
Pausing state's exhibit at 5 minutes and 38 seconds. At this time, was Mr. Perez under arrest?
No, ma'am.
Okay. Did you ask him any questions prior to putting him in the patrol unit?
No, ma'am.
Resuming state's exhibit at 8 minutes and 48 seconds.
Where's your right? So now you know. And it doesn't mean you're under arrest. It's giving you a warning. That's all it is. It's your warning. Before you ask any questions, it's my duty as a police officer to advise you of your rights and to warn you of the consequences of waiving these rights. You have the right to remain silent. You don't have to make any statement or written anything. Any statement that you make will be used in evidence against you for law or education. You have a right to have a lawyer present who advise you before and during any questioning by police officers or attorneys representing the state. You may have your own lawyer present, or if you're unable to employ a lawyer, or will appoint a lawyer free of charge now or any other time. you decide to talk with anyone, you can stop talking to them anytime you want. The above rights are continuing rights which can be heard from you at any stage of the proceedings. We understand these rights. Yes. So, what's going on? I don't know over here. Yesterday, that you smart, someone was hiding. I do it, we take on the check, I guess it's about shit. Okay, so you're doing a for that. You wrote your check. So, I mean, second time I come over to cash for this, so you already tried cash for this check and bounce? No, they just, they never give me the cash flow. And when was this? Today. Like earlier today? Oh, right now. I thought you said this is the second application. So yesterday I came, I cashed it, no problem, and then I got paid again today, and I cashed it. And they didn't say you anything? Any questions? No, they said, no. Sounds like. Yeah. Alright, so you came to cash check. Alright, I got paid for it. Alright. Decide what you're doing on this contract work, so. So. I'm bringing it up, so when you give it to them, they just didn't give it back, they didn't give any explanation? She's like, no, so she said. Okay. So for now, we're just gonna kind of chill and wait, okay? Yeah. We'll try to get you out as quickly as we can. We're gonna clear everything up and. So my partner's talking to them. Oh, this is so messy. That's just, it's accurate. You didn't get in there. Yeah, I know, that's just how different people are.
Pausing states exhibited 11 minutes and 17 seconds. Officer Shawway, after you read Mr. Perez his Miranda, did he acknowledge he understood them?
Yes, ma'am.
Did Mr. Perez waive his Miranda rights?
No.
I'm sorry?
No.
No, he did not waive his Miranda rights?
Oh, he just understood, and then
Did he agree to speak with you?
yes.
Okay. At any point, did you threaten the defendant to speak with you?
No, ma'am.
At any point, did you coerce Mr. Perez to speak with you?
No, ma'am.
Did you promise Mr. Perez anything in exchange for him to speak with you?
No, ma'am.
At any point, did Mr. Perez ask for an attorney?
No, ma'am.
I pass the witness, Your Honor.
Defense?
Yes. After. You said that you received a nominal amount of information from 911 dispatch when you went to the bank.
Yes.
Did they tell you that Mr. Perez was a flight risk or dangerous?
In the note, it said that he was trying to leave the location.
And so when you arrived at the scene, was he running away or actively trying to?
No.
So whenever you got there, you confirmed that he wasn't the flight risk. But as soon as you got there, you immediately put.
Yes.
Yeah, but you said that he wasn't under.
No.
What if he would have? And he asked you a few times. Said, "Am I under?"
And I advised him no.
You told him.
He's being detained.
That he wasn't free.
No.
What if he would have asked you?
I would have told him no. He's being detained because there's reasonable suspicion that he possibly committed a crime.
At that point, would you have any evidence at all?
Not at that time, because I just spoke minimal to the complainant.
Did you look at the check or look at anything or verify anything that came into the 911 call before you did that?
I did not.
So at the time that you put him in custody, you had no reasonable suspicion about the crime.
I was just going off of what the complainant called for initially and said that it was a false check that was flagged.
And then basically you talked to him for a couple minutes, then essentially you handed him the officer back, right?
Yes.
Then you didn't really have much to do with the case after that.
At that moment, yes.
Thank you. That's fine.
All right, any further questions?
Not for this witness, Your Honor.
All right, you may step down. All right, call your next witness.
State call Zachary McFadden.
Could you raise your right hand for me, please? You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. And if you'll state your name for the record.
Officer Zach McFadden.
All right, state, you may proceed.
Yes, sir. Officer McFadden, were you on duty on March 7th, 2025?
Yes.
What area were you assigned to?
The south side, South Patrol.
Okay. On the south side, were you dispatched to any calls?
Yes.
Where were you dispatched on March 7th, 2025?
To the Wells Fargo Bank off of South Zarzamora.
Okay, prior to arriving to the Wells Fargo on South Zarzamora, did you have any indication what you were being dispatched for?
Yeah, the caller called dispatch indicating that a Hispanic male wearing a reflective vest of some sort was trying to pass a check, and that their fraud systems caught the check and they needed police to arrive there.
When you arrived to the bank, what did you observe?
My partner and I both arrived to the bank, and I observed a Hispanic male wearing a reflective vest in the parking lot, getting ready to leave in a vehicle. And so I went to go detain him, and my partner went inside to talk to the caller. And that's when the caller indicated that I had the wrong person in custody. So he was released, and then we took the accurate suspect into custody and began questioning him.
Okay, so on this call, you stated that you had a partner. Were you all in the same patrol unit?
No, two different patrol vehicles.
Okay, who was the handling officer on this case?
I was.
So as the handling officer, were you the officer tasked with investigating the call?
Yes.
Okay, and how did you investigate this call?
Piece by piece. First, the suspect was written his. We read his Miranda rights, and he was advised that he was being detained on reasonable suspicion that we had a fraud case in front of us. I went and talked to the caller, which was the employee at the bank, who stated that their fraud system picked up a possible fraudulent check. And then once we determined the details from the caller, eventually I was able to get in touch with the owner of the check. And then the owner of the check stated that he didn't give consent for the suspect to be using his checks, or he didn't write any checks to that person. And it was from a very old checkbook as well.
Okay, so you stated the suspect was Mirandized. Did you Mirandize the suspect when y'all initially detained him?
No, when he was initially detained, it was my partner that Mirandized him.
Where were you when he was Mirandized?
I was inside the bank talking to the caller.
At that point during your investigation, was Mr. Perez under arrest to your knowledge?
No.
Why?
At that point, we were still gathering evidence, still piecing together this case. It took quite a while to piece it together. So at that point, he was just being detained while we were investigating a crime. And at the point that we had probable cause to make an arrest, he was under arrest. But at that point, he was just detained and read him his rights.
When he was initially detained, was he placed into handcuffs?
Yes.
Why was he placed into handcuffs?
That's just for officer safety and for the safety of anyone that we're dealing with. In law enforcement as a whole, but especially on the south side, we deal with a lot of violent crime, a lot of firearms, a lot of weapons. So we found that both in trial and error and just in a general system of law enforcement, that anytime we leave people out of cuffs, there's a lot of opportunity to use weapons or to assault police. And when that happens, usually to get them into custody causes them to experience bodily harm, us to experience bodily harm, and also puts the public at risk as well for someone evading, someone shooting at us, us shooting towards somebody. So as a whole, we just put them in handcuffs and then frisk them for weapons.
Okay, perfect. So when you, prior to arriving to a call that you're dispatched to, do you receive information about what you may be coming upon?
Yes, we get verbally dispatched from our dispatcher over the radio saying that we're headed to the address, and the general nature of the call just being that it's I think this one was a fraud was the title of the call, something like that. Then on our laptop computers in our patrol vehicle, we can see whatever details the call taker is putting on our call screen, where they're talking directly to whoever the caller is and they're typing out sentences on our computer. So I think if I remember right, an example from this one was that a Hispanic male wearing a blue shirt and a reflective vest was trying to pass fraudulent checks at the bank. And then another detail was that he was getting agitated or nervous or something to that extent and was trying to leave. And so those were the general details that I read before getting there, and which kind of led me to detain that one guy in the parking lot to keep him from leaving, because in my mind, got someone matching that description, at least with the reflective vest side of it, and he was trying to pull out of the parking lots.
Based on your experience, are the details in the key cards, so for example, regarding clothing, are those always accurate with what you
No.
observe on the scene?
No, in fact, I don't want to give a specific number, but I'd say very often they're about half right. And so sometimes somebody might say someone's wearing a blue shirt and red shorts, and then in reality they're wearing just the red shorts, or they're wearing just the blue shirt. So that's a human error thing. It happens with us as well. We're just human, and everybody makes mistakes, especially in a stressful situation. So if we can find one piece of evidence that kind of corroborates someone being in the area, someone matching description by race or ethnicity, someone matching description by clothing, we'll go ahead and start to at least have consensual encounters, but usually detain based off of that, based on severity of crime, obviously.
Okay. And on March 7th, 2025, were you equipped with body worn camera?
Yes.
Your Honor, may I approach?
Yes.
Sorry.
Oh, thank you so much. You're welcome.
On March 7th, 2025, Officer McFadden, did you have Coban on your patrol unit as well?
We have the mounted cameras on the vehicle. Yeah, I think it's Axon at this point.
Okay.
Yeah, we had the mounted cameras on the vehicle.
And the mounted camera, is that the front of the vehicle and rear?
It's the front and then the prisoner compartment.
Okay. Perfect. I'm handing you would have been marked as states exhibits M2 and M3. Do you recognize these?
Yes.
What do you recognize them as?
It's body worn camera footage that I reviewed today and then initialed, and then it is also, I believe, footage of the prisoner compartment that I reviewed and initialed as well.
Okay, are these fair and accurate depictions of your video on March 7th,
Yes,
2025?
yes,
To your knowledge, have they been altered and amended?
not to my knowledge.
At this time, your Honor moves to admit would have been marked as states M2 and M3.
Objection.
All right, States Exhibit M2 and M3 are admitted without objection for purposes of this hearing.
Thank you, Judge. Permission to publish?
Granted.
Playing States Exhibit at 19 minutes and 44 seconds.
What, what happened on the bank's end is they had some sort of automatic system, warning that indicated that there was possible fraud. They didn't share with me how their system works. I don't know how that system works, but what they did from there after the automatic warning was they called the, owner of the check and, asked him if he had, written his check. So, I got a little bit more information than that, but, I just want to kind of get your side of things here. So you do work at the, you said where did you say you worked your primary job? Yeah. Okay. 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 Oh, wow. Okay, so this check we have up here, do you know the owner's name? I did not, So walk me through, let's pretend like I know absolutely nothing at all, just walk me through the arrangement of what happened with regards to this check. What kind of work was it? Concrete work. Like residential or commercial? Okay. Okay, so. Okay, so did you complete the work? Did you complete the work? Okay, did you get started?
Pausing States Exhibit at 22 minutes and 6 seconds. At this time, Officer McFadden, was Mr. Perez under arrest?
No.
No. At this time, to your knowledge, was he already Mirandized?
Yes.
Who Mirandized him?
Officer Chavez.
At this time, did you coerce Mr. Perez to talk to you?
No.
Did you threaten Mr. Perez to talk to you?
No.
Did you promise Mr. Perez anything in exchange to talk with you?
No.
To your knowledge, was Mr. Perez speaking with you voluntarily?
Yes.
At any time, did you tell Mr. Perez he didn't have to talk to you?
I don't recall. I don't remember.
At any point with your interaction with him, did you Mirandize him yourself?
Yes, I believe I was watching body camera footage earlier today and realized I Mirandized him a second time.
Okay.
After I Mirandized him as well as Officer Chavez later.
Why did you Mirandize him?
One, just the length of this call. It was several hours while we were trying to find a detective to handle this case. And so I like to dot my I's and cross my T's, so to speak. And also, once I felt that we had enough evidence on the table to move towards an arrest, I believe that's about the time frame where I Mirandized him again.
I pass the witness.
All right, defense, you may proceed.
Yes, good afternoon.
Afternoon, sir.
You mentioned that you do some things in terms of guns and keeping people in cuffs, especially in the South Side for safety in general. But in particular, there was nothing aggravating about this call that would necessarily require you to.
No, it's more of the area. I've worked that area pretty often, the Zarzamora and Southwest Military area. And I've dealt with quite a bit of death in that area. Not anything specific at the moment I'm going to get into, but when it comes to that Wells Fargo over there, they regularly have a off-duty police officer stationed over there just because of the prevalent violence and then gun-related activity in the area.
Was there one there that day?
I don't remember. I know it was near closing time. I typically will see whoever's working that area. I don't remember if I saw him or not. It's been back in March, but typically we do see at least one of the guys out there. If we're working something on the street, they'll wave. We'll see each other. So
Mr. Perez, whenever you made contact with him, was actually like very cooperative, right?
yeah. Mr. Perez was cooperative, was nice, was by all accounts didn't give us any problems or was disrespectful or anything like that to my memory or when I was watching body cam footage today.
And so after Officer Shawway Hernandez, he handed them to you. Right?
I'm
Did
say
you
that
look
again?
to put them in your car?
Yes, sir. Yeah, just because I was handling, we switched handcuffs so that Officer Chavez could get back in service, and then I placed him in my vehicle. Yes, sir.
Okay. And it's fair to say that he was in your car for like over 3 hours.
Yeah, and I'm sure that was uncomfortable. And yeah, I wasn't happy about it either. But yes, he was in there for at least multiple hours. I don't know the exact time.
Maybe almost 4 hours.
It's possible. It was a long time. I think if you watch the video footage, you watch it go from daylight to nighttime. Yeah.
Okay. And over the course of all this time, he was never under arrest until the very, very end.
At the point that he was going to be arrested, at the point that he was under arrest and was going to be booked, I advised him of that. After speaking with the detective and allowing the detective to make the final determination over the phone, that was when we made the decision he's going to be booked on this offense. I advised the Mr. Perez of the decision.
For those 4 hours he was in his car, did you ever offer him water?
I don't recall if I did or not.
I'm surprised you did.
No, I typically don't offer people fruit or water, only because I don't carry it for our folks that we're taking into custody.
You typically don't have people in your car for 4 hours.
It depends. If it's a critical incident, we could have people in our car for 6 hours or more. In those cases, we typically have a lot of resources on scene, and if there's a need to go get food or water, we will. And if I knew this case was going as long as it was, to be just perfectly blunt with you, I probably would have had somebody like, let's take care of him some way. Let's maybe get him into a different chair, get him some water, something like that.
That's not what was done.
No. And even to my own frustration of trying to find a detective over all of those hours, it just went from 1 hour to the next. Keep thinking we're going to be done in about 15 minutes. We're going to be done in about 15 minutes. And it just kept
He was
going.
sitting in the back of your car all this time and can't go.
Yes.
Did not.
No, he was not free to go. He was detained.
Okay. And so basically you would talk to him for a bit and leave and come back. So it was basically like a 3-hour interrogation session, right?
For the however many hours it was, yeah, he was being questioned after he was read Miranda rights. And so he also advised us both times that he understood his rights, which were read to him. And so, yes, all the questioning that took place was willful on his own end.
And at one point, you actually have a conversation with one of your fellow officers where you say, this should probably be an at-large case or something, right? Can you say something along those lines?
I don't recall exactly, but yeah, you're reminding me of something. Yeah, that essentially you have a decision to go, we can either arrest on this because we have enough evidence to arrest, or this needs to be pushed to a follow-up unit and they could file at large to issue a warrant for the arrest
And the
later.
reason I ask you that is because it at least showed an awareness on your part that like you're keeping him in custody forever. It's getting like kind of unreasonable at this point. So maybe you should let him go and follow up with an at-large case once you have a third investigation.
I do understand the questioning. So I would say if there was no progression in the case within those hours, then and we were just sitting on the same amount of evidence that we started with, the same amount of knowledge, the same amount of statements, then I could definitely agree with a statement like that, especially for the amount of hours we're talking about. But the reality of this one in particular was there was a steady progression, although it was slow and annoying to everybody involved. There was a progression where we had to get a detective because of the nature of the case being fraud, and that does go to a follow-up unit. And we also had to speak with everybody involved, the tellers at the bank, the employees of the bank, and then eventually get in touch with the victim, the owner of the checks, and get his statements over the phone, kind of establish who he is. He had a lot of statements to make to me over the phone, and my main thing I was trying to establish was, is anything the suspect saying here credible? Because the facts changed quite a few times, or I'm sorry, the statements he was making changed quite a few times. And I understand that that could be a number of factors.
That's the question.
Oh, I apologize. I'm sorry.
And just one last question. At any point, up until the arrest, he was not, even though he was sitting in your car in handcuffs, he was not free to leave.
I'm sorry?
He was not free to leave.
No, he wasn't free to leave.
Never applied.
No.
But you told him that a couple times, that he might be released.
I told him that, yeah, based off of whatever may occur in my investigation, that he may be free to leave it that day. In my mind, I was going from, first, I need to determine if we even have enough, if there's even been a crime committed. So when I'm talking to people, very oftentimes, we will put people in handcuffs that get released later because there's a lack of evidence. And then in other cases, it's a at-large case. And in both cases, they're released from handcuffs that day and they're walking. So I advise people of the possible outcomes for a case, just for the sake of, I don't want people freaking out or to be unnecessarily worried in my back seat, thinking that I am going to be arrested absolutely because I'm sitting here in handcuffs. Because very often people are in handcuffs in my backseat who do end up getting released that day without ever being booked. So I advise them of the possibilities.
One last question.
Yeah.
Going back to the very beginning, who was the officer that arrested the first person? Is that you?
The officer that detained the person who ended up not being the suspect. Yeah, that was me.
Officer McFadden, you stated that you were waiting on a detective. Why were you waiting on a detective?
So a little complicated, but we have a lot of follow-up units on the department that their working hours end at about 4:30 in the afternoon, as a lot of businesses do. And I believe our fraud unit, or the unit that deals with fraud cases, was getting off at that time. The time that I was conducting a large portion of my interview, hey, I'm looking at the screen right now. It says 17:08, so it's after 4:30, and the next major detective unit would be night CID, and they get on at, I believe, 7 p.m., which would be 1900. So there's what's called a gap detective, a detective or a couple of detectives that bridge the gap between the follow-up units and then the night CID detectives. So during that gap, it seemed that there was a very heavy volume of cases coming into the gap, where I wasn't able to get either in touch with a detective at all or a detective that was able to handle the case.
Okay, and then at any time, did you allow Mr. Perez out of the car?
Yeah, I believe that we exited the car. I know for sure at least once, because we switched him from a single pair of handcuffs to double handcuffs to give him a greater comfort, a little bit more motion in the shoulders. And I also allowed him the use of his personal cell phone to call work because he was concerned about missing work or something. So just based off of the length of everything, we don't normally do things like that, but it was a very long situation, and I wanted to give him every opportunity to call work or do whatever he needed to do that wouldn't compromise the case, but would also just recognize him for his human needs and things of that nature.
During the course of your investigation, who did you talk to?
Several detectives and the victim. I don't remember the victim's name at the moment, but the owner of the checks, as well as the suspect, and then caller, the person who called 911, and then other employees of the bank.
And at what point did you determine that a crime had been committed sufficient to place Mr. Perez under arrest?
Based off of multiple conflicting statements from the suspect as far as the nature of how he got the check, what the check was for, his relationship to the writer of the check or the owner of the check, the nature of his work, the location that all of this occurred on. There was a lot of conflicting statements that were made by the suspect while I interviewed him. So there was that, but the nail in the coffin, so to speak, was the owner of the check telling me that the numbers on the check numbers at the top, were from quite a long time ago. They were like hundreds of checks off from his current checks being used, and that he did not give effective consent for anyone with the suspect's name to be writing or cashing those checks. And he didn't have anybody matching that description or with that name that had completed work that he claimed to have completed. And so it was all of those statements and piecing that together, notifying the detective of that, and then the detective determining we're making an arrest.
And do you recall approximately what time you were able to make that determination?
I don't. I just remember it was after dark.
And then regarding Mr. Perez, did you check on him at any point while you were waiting for people to call you back?
Oh yeah.
Yeah.
Quite a few times.
I pass it, Mr. Honor.
All right, defense.
So the state made reference to 3 checks that you wrote about in your report.
Yes, sir.
So the check, probably not aware, maybe you're aware that the only check that was indicted was 1 check. Check covered that day, 674. Did you do
Your
any?
Honor, this is outside of the scope of the motion.
She asked about the other checks.
I did not ask about a check in this hearing.
All right, so what the court is focusing on is whether or not the statement the defendant gave was voluntary. And I believe that's the motion that the defense has filed.
Just a couple other questions around scopes. That all.
All right, any other questions from either side?
And from the state, Your Honor.
All right, is this witness excused for the purpose of this hearing?
Yes, Your Honor.
All right, you may step down. Thank you.
Oh.
All right, any other witnesses?
None from the state, Your Honor.
All right, then the court will hear argument. Defense is your motion. You may proceed.
Yes, Your Honor. I would encourage the court to grant my motion to suppress the statements that the evidence that was shown here shows that he was in custody for a total of 4 hours. He was never offered water at any point. Yes, he was Mirandized getting, but I don't think it was proper because they didn't have any reasonable suspicion or probable cause to put him into custody, detain him at the beginning. They had nothing. not a thing. They said he showed up and arrested him. So, I don't think that was reasonable. He was basically put into custody immediately. I don't see how you can be in a pre-arrest detainment for like 3 hours. That just doesn't seem reasonable to me. They could have proceeded a number of different ways, which they didn't. It's not really his fault that it was in the South Side, and that's what they do, or that they couldn't get a hold of who they needed to get hold of. They didn't have enough evidence. They put him in the cuffs. They didn't feel like they had enough evidence until like almost 4 hours later. So for that reason, I think it was all unreasonably done. And anything he said to them was improper.
Right. So, from the court's reviewing of the state's exhibits, I believe it's M1, M2, and M3, our party stipulating that Mr. Perez was Mirandized before he gave any statements.
Yes.
Yes.
All right. And do parties both stipulate that the Miranda warnings that were given were the appropriate Miranda warnings? I'm
Yes.
not getting to the fact of whether it was voluntary or not, but just that these are the standard and constitutional Miranda warnings that are given.
Words. Yes.
Okay. So then defense, your entire issue is whether it was done voluntarily, correct?
Yes, sure.
All right. So how are you saying, or your belief that it's not voluntary?
Judge, they did read him his rights initially, but then they held him in custody 3 hours after, actually almost 4 hours after. So, I mean, I don't think it's reasonable that, if they Mirandize you in the beginning and then they hold you for 8 hours, is that reasonable? And everything you say after that is, and if they have you in handcuffs in the back of a police car, this isn't like your typical type of interrogation that maybe would happen in a conference room with the police department, where a lot of times they don't put people in handcuffs, they just talk to them. This is by definition like a way more suggestive way to handle it. He was never given water. He was held in handcuffs for 4 hours. They never really gave him a chance.
So are you saying that the evidence presented that he was detained or in handcuffs for 4 hours?
Yes, sure.
And when are you suggesting that the Miranda warnings were given and the statement was made by your client within that 4-hour time period?
I believe so. The Miranda warnings were given pretty close to the beginning of the 4 hours. And the officer, my client, makes some statements initially after that, whenever he's transferred into a car. And then what essentially happens is the officer stops, then leaves, calls somebody, leaves him in the back of the car, comes back, does the same thing, asks him some more questions, leaves, comes back, talks to another officer, comes back. So it's like an ongoing.
So when is you're saying that it was approximately 3 to 4 hours that he was detained? Or let me correct the record. You're saying that it was approximately 3 or 4 hours of him being in handcuffs in the patrol vehicle?
So he was in handcuffs 4 hours.
Okay. So the question the court wants answered, and I'll review the entirety of the videos, but what time frame from the last time he made him a statement to when he was Mirandized, what is the time frame between that? Does anyone know?
Are you talking about like from first Miranda to second Miranda?
To the Mirandized with this last witness, when this witness Mirandized him, this is what
He didn't Miranda.
No, he stated,
No, they both.
When he arrested him.
Yes,
At the end
he
of the
sta-
video.
yes. So what I want to know, and I will review the video, I want to know what is the length of time between Mr. Perez being Mirandized and the beginning of the statement he's alleged to have given the officer and the ending of the statement that he gave the officer. Does everyone understand what the court is requesting?
Yes. And you mean when he doesn't say anything else?
No, just his last statement. For example, hypothetically, if he's Mirandized at the very beginning, after he's been placed in handcuffs and in a vehicle, I want to know, and I'll watch the video to see, but I'm trying to make sure that you all give me the argument because this is the crux of the issue here. So he's Mirandized, placed in handcuffs in the back of a patrol car, gives a statement. From the time he was Mirandized to the first statement of words he speak, what is the lapse in time? And then what is the lapse in time from the time he was Mirandized to the end of the statement that the state is seeking to have admitted? Those are questions that the court wants answers to because both parties have stipulated that he was Mirandized. So for the court, whether he is in custody or not in custody, he's been Mirandized. So then there are other issues that the court needs to consider to make a ruling on whether or not the statement should be admissible. And those are one of the issues I want addressed. So does anyone know the answer to those questions or?
If you just give us a couple of minutes, Lauren does have some timestamps. We'll go through them and try to get them to you in a couple of minutes.
All right. And so defense, if you'll review the time steps with them as well. And of course, as I said, I just want to hear your arguments on that point and any other arguments you want to make, but I will most definitely review the videos as well. All right, the court will hear argument. Defense, it's your motion, so now that certain things have been established with regards to Miranda, I'll hear your argument.
Yes, Your Honor, I believe the court asked for some briefing on the timestamps, when things happen,
Yes.
of course, the video. And so I re-reviewed it,
Mhm.
and it looks like, my client was Mirandized at 16:49 or 4:49, on March 7th. There was basically a few immediate statements, the officer Mirandized him, then he was transferred to another car at 16:55 or 4:55 PM. At which time there were statements made at that point.
All right, so I'm sorry. So you're saying he was Mirandized according to what you viewed at 16:49,
Yes.
and then a statement was given, and then he was switched to another vehicle at 16:55?
Yes, it's not re-Mirandized.
Okay. All right, you may continue.
Then it looks like there's essentially continuous statements that are made, continuous questions with or without breaks until about 1914 on the timestamp, which I guess would be 7:14.
Yes.
So
So is 7:14 the conclusion of the alleged statements from your client?
I don't see any statements that he made after that.
After what times?
7:14, I guess I have like 2:28 or so.
What is that?
Timestamp. Yeah, that was, yeah.
Great.
I was looking, so I don't see any statements that made by him after that.
Okay.
So it's about 3 hours. I think until they stopped asking.
All right. State.
Your Honor, regarding the timestamps, I was unclear whether Mr. Ambrosino was using the bottom like VLC seek or the top right corner. But I have on my review that Mr. Perez was first Mirandized according to the top right timestamp of the body worn and Coban videos. First Miranda was at 16:55 and 20 seconds is when Officer Shawway reads the Miranda warnings. At 16:56 and 1 second, Mr. Perez makes his first statement. He exchanges from Shawway's vehicle to McFadden's vehicle at 17:03 22 seconds. He is then re-Mirandized by Officer McFadden at, what is this, 19:44:45. And then his last statement I have him stating is at 19:47:30. And Your Honor, we would just ask that because he was Mirandized, he agreed to speak, that you find that it is voluntary. He was let out of the vehicle twice during this interaction, and as testimony heard, was that the investigation was progressing. It was just slower. They were during the gap period, and although he wasn't offered water, reasonable accommodations were made for him, such as allowing him out of the vehicle to call work. They allowed him to be double cuffed, which was at 18:14 and 18 seconds. I'm sorry, 18:12 and 12 seconds. And Officer McFadden did check in on him multiple times throughout the time and tried to keep him apprised of what he was doing, such as he's waiting on the detective trying to get in contact with the proper people. So we would ask that you deny defense's motion.
All right, defense, it's your motion, so I'll allow you final argument.
This judge, I don't think that this was a reasonable amount of time to have somebody pre-arrest detained. I mean, he was kept in the back of the car for at least 3 hours before he was actually put under arrest. There was no safety concerns, there was no other reason for him to be held in cuffs under those conditions. He was not offered water, he was not given anything to accommodate him. I understand there's issues that part of town, but there's nothing extenuating about this particular case, with this particular client. That was merely that, so for that reason, I asked you to provide statements.
All right, so what about being allowed access to his cell phone to make phone calls and being allowed out of the vehicle and being double cuffed for more comfort?
So I did see him get access to a call. At one point. I think most people are getting a call, one call, and something like that's pretty common. With respect to the handcuffs, I believe he did that pretty early.
Hmm.
That wasn't something he did like 3 hours, did it? Not too long after he was transferred.
Okay. All right, so what I'm going to do is, if there's no objection by the state or the defense, if you will leave the unredacted versions with the court reporter, I'll review them. And if you all are here tomorrow, well, I shouldn't say if you are here, I would like for all of you to be back here by 1:25, and I'll give you my ruling. And we're off the record. So if the court were to deny your motion, have you all reviewed the redacted version? And I know you'll still have objections if I were to deny your motion, but is there any issues with the redacted version if the court were to deny your motion?
The issues with the redacted version, well, she's not done with it, though, right? Did you get it back? Or, because then you have to kind of turn it. in.
So if you all could.
Do it for you.
It's on the desk, so it was
Oh.
done.
Okay, so my issues in the motion limiting with regard to that are basically extraneous offenses and
Mhm.
the other checks. That was really mostly.
All right, so this is what I want you all to.
Extraneous.
All right, so if you all could go upstairs and make sure that he sees the redacted version. And before you all leave here today, if you can look at it, and if there's some issues in there, if the court would deny your motion, let me know so that I can make rulings upon it so that the jurors, if they're here exactly at 1:30, we can start at 1:30.
Yes, Judge.
Okay. So if you will go up and grab that.
This,
And